Welcome to the webinar presented by the Office of Court Administration, or OCA, on the Appointments and Fees Report. My name is Sandra Mabbitt, and I am a Judicial Information Analyst at OCA, where our mission is to provide resources and information for the efficient administration of the judicial branch of Texas. Reporting of appointments and fees involving amounts of $500 or more in all civil cases has been required by Supreme Court order since 1994. Due to poor reporting, the legislature created Chapter 36 of the Government Code to statutorily mandate reporting of certain appointments and all fees paid for those appointments. Although certain reporting is now legislatively mandated, the Supreme Court decided to leave its order in effect to continue to capture the other information not covered by the statute. To make the two different reporting mandates more consistent, the Texas Judicial Council added a rule to the reporting requirements of Chapter 171 of the Administrative Code that requires the reporting of any fee paid for an appointment in a civil case, not just fees of $500 or more.
First, let's go over the requirements of Chapter 36 of the Government Code. The code requires every court in the state to report all appointments of and any fees paid to an attorney ad litem, guardian ad litem, mediator, or competency evaluator. This applies to any type of case, including criminal and juvenile cases. However, most jurisdictions will have little or nothing to report for criminal and juvenile cases, since the vast majority of appointments occur in civil cases. Note that the reporting requirement does not apply to attorneys appointed for indigent defense in criminal and juvenile cases. Information on those appointments are reported to the Texas Indigent Defense Commission. In addition, the requirement to report competency evaluators does not apply to criminal or juvenile cases either, as the reporting statute defines a competency evaluator as a physician or psychologist who performs examinations to determine whether an individual is incapacitated or has an intellectual disability for purposes of appointing a guardian for the individual. The statute also lists 4 types of appointments that do not need to be reported. These are a mediation conducted by an alternative dispute resolution system established under Chapter 152 of the Civil Practice and Remedies Code, an attorney ad litem, guardian ad litem, amicus attorney, or mediator appointed under a domestic relations office established under Chapter 203 of the Family Code, a guardian ad litem or other person appointed under a program for volunteer advocates in child protection cases authorized by Section 107.031 of the Family Code, and case information made confidential under state or federal law, including applicable state or federal rules. An example would be judicial bypass cases. Now let's discuss Supreme Court Order 07-9188 and Chapter 171 of the Administrative Code, which require the reporting of appointments in civil cases for any position for which a fee may be paid and reporting of any fees paid to the appointee. This includes family, child protection, probate, guardianship, and mental health cases. The Supreme Court order does not apply to criminal or juvenile cases. The order also excludes 3 situations from the reporting requirement. You do not need to report cases in which a party has the right to select the appointee. An example of that would be when a will names an independent executor or a trustee of a testamentary trust. Cases in which the appointee is compensated solely by government salary, such as masters or referees, or cases in which the appointee serves in a non-judicial capacity, such as process servers or substitute court reporters. The Supreme Court Appointments and Fees Report has commonly been referred to as the ad litem report. However, Appointments of ad litems are not the only appointments that are required to be reported. Shown here is a list of potential positions to which an individual may be appointed and receive a fee for. This list may not be complete, so if you identify other positions, please contact our office. Every court must submit 2 reports each month. One report is for all appointments made during the month, and the other is for all fees approved or paid during the month. Section 171.9A of the Administrative Code removed the $500 threshold in the Supreme Court order for reporting fee payments. As a result, all appointments and fees in civil cases are to be reported, regardless of the amount of the fee. In addition, every court in the state must submit the 2 reports each month, even if the court has no activity to report. Now I'd like to discuss the information you will need if you do have activity to report. For each appointment made, you must report the name of the judge or magistrate who signed the order, the name of the court, and the case number and style of the case. In cases where the confidentiality of the parties needs to be maintained, the case should be styled to preserve that confidentiality. You must also report the name of the person or entity appointed. Note that the person's state bar card number must be included if the person is an attorney, the position to which the person or entity was appointed, if relevant, the relationship of the appointee to the ward or deceased, and the date of the appointment. For each fee paid, you must report all of the same information that was reported for the appointment, except for the appointment date, as well as the date the fee was approved or paid, the source of the fee, and the amount of the fee. In addition, if the amount of the fee is greater than $1,000, the report should also include the number of hours billed and the total amount of billed expenses if the information was made available to the court. Note that the reporting requirements do apply to cases that are sealed or made confidential by local rule, so remember to use discretion when reporting the style of the case. The requirements also apply to fees in which a source other than the county pays, such as the example shown on the screen. We have received many questions whether reporting requirements apply to local practices. So let's discuss some of those. The first cases we'll discuss are regarding mediators. You should report cases when the judge selects and appoints a mediator because the parties involved cannot agree on one. Also, when the parties have no say in the selection of the mediator. An example would be when the judge authorizes mediation, but the actual assignment of the mediator is handled by another party, such as the district attorney's office. In any of these situations, report any fees approved or paid, including fees from sources other than county funds. You will not report mediators when local rules mandate mediation for nearly all cases and the county or court does not maintain a list of the mediators. The parties can agree on a mediator. The judge may sign an agreed appointment order, but does not select the mediator. Or the judge authorizes mediation, but the assignment of the mediator is handled by another entity, such as the district attorney's office, and the parties have a say in the selection of and agree on the mediator. Now let's go over what to report when an attorney ad litem or guardian ad litem is under contract for a set fee. When reporting the appointment, if the appointee is a law firm, report the name of the law firm as the appointee or the name of the specific attorney that is serving as counsel of record on the case. If the appointee is an individual, report the name of the attorney. Note that in these cases, the fees paid do not need to be reported. In cases where the appointee is from the Office of Child or Parent Representation as established under Section 107.061 of the Family Code, you will report the appointment and list the appointee as Office of Child or Parent Representation using whatever name it is called in your county. Note that in these cases you do not need to report the fees paid.
In cases where the attorneys are on a list maintained by a managed assigned counsel program as established under 107.101 of the Family Code, you will list the appointee as Managed Assigned Counsel Program using whatever name it is called in your county. You will report the fee if the appointee is paid to Managed Assigned Counsel Program on a per-case basis, or fees are paid directly to the attorney on a per-case basis. You will not report the fees if the fee is a set payment, monthly or annually, regardless of the number of cases.
Now let's talk about how you will go about collecting the required information. The Supreme Court's order requires each appointment to be made by a written order, each approval of the payment of a fee to be accomplished by a separate written order, and orders making appointments or approving the payment of fees to be sufficiently specific to enable the clerks to prepare the required monthly reports. Judges and clerks need to determine locally how the required information is to be obtained. Examples of forms used by a few courts can be found on our website.
Courts should be aware that if a court fails to provide information to the clerk's office so that they can report as required, Chapter 36 of the Government Code states that the court is ineligible for any grant money awarded by the state or a state agency for the next state fiscal biennium, which begins September 1st, 2017. Now that we have gone over the reporting requirements, let's continue to the submission and posting of the report. The report for the previous month's activity is due by the 15th of the month to OCA. Chapter 36 also requires the clerk to post the report in the courthouse by the 15th of the month and post the report on the court's website by the 15th of the month. We suggest posting the report on the clerk's website. You must submit your report online through our reporting database at card.txcourts.gov. You will use the same login ID and password that is used to log in and submit the monthly court activity report. Just like the monthly court activity report, the option to submit the report by manually entering the information is available, as well as the option to upload an XML file. In order to upload an XML file, your case management vendor or local IT staff will need to format the report to the XML specifications available on our website. And again, remember that the report must be submitted for each court, even if there is no activity to report.
Once you have logged in at card.txcourts.gov, you will select the Appointments and Fees button. To enter a report manually, select Add New Record. A data entry form will then appear. The reporting period will automatically default to the month and year that is due at the time you log in, so make sure that the dates reflect the month and year you want to submit a report for. If they don't, make the necessary changes. You will then choose the type of activity, either appointment or fee. If you have activity to report, complete each field, go to the bottom of the report, type your name in the Prepared By line, and click on Submit. If there is no activity to report for the month, check the No Activity box, go to the bottom of the report, type your name in the Prepared By line, and click on Submit. If you complete all the required fields correctly, you will receive a message that the record was saved successfully. Once you click on OK, You will be returned to the screen where you may add another record. If you don't have more records to add, you can simply log out. If there are any fields that are incorrect, incomplete, or missing, you will receive an error message in red at the top of the page. Any errors will be listed to make you aware of the corrections you will need to make. Once you have made the corrections, go to the bottom of the page and click on Submit. After all corrections are made, you will receive the Record Saved Successfully message. As of October 1st, 2016, if you have not submitted reports for months prior to September 2016 and you would like to manually submit them, you may do so. For the type of activity, simply select Fees and then complete the information using the older report format. That is all you'll need to do. You will not need to submit reports for appointments. If you wish to upload an XML file, your case management vendor or local IT staff will need to create the program to generate an XML file from your case management system. OCA has created instructions for vendors or IT staff to create a properly formatted XML file. To receive information on the XML instructions, you may send an email to judinfo@txcourts.gov. To upload your report, you must first generate an XML file from your case management system and save it on your computer. Once you have created the file, log into the Appointments and Fees database and select the Import XML button. On this screen, you will click on Browse, find the file you saved on your computer, and double-click on it so that it populates in the browser bar. To complete the upload, you will then click on Import. If you upload an XML file and the file meets the XML specifications, you will receive a message that the import was successful. If the XML file does not meet specifications, you will receive a message indicating what is preventing the file from uploading successfully. You will then need to contact your case management vendor or local IT staff to make the necessary corrections. As of October 1st, 2016, if you wish to upload reports for any month August 2016 and earlier, the XML file must meet the specifications for the new reporting format. If it does not meet the specifications, you will receive an error during submission. Note that the file does not need to contain appointments, only fees.
You will find the reporting instructions on our website at www.txcourts.gov. To get to the information on the Appointments and Fees report, click on Judicial Data, then Reporting to OCA, then Appointments and Fees in Civil Cases, then Senate Bill 1369.
This is a direct link to the web page for Senate Bill 1369 reporting requirements, which I encourage you to save as a favorite. This screen shows the information available on the Senate Bill 1369 webpage. Here you will find the instructions, spreadsheets you may use to complete the reports, as well as frequently asked questions and other helpful information. If you have saved this page as a favorite, you can check periodically for updates we have made. The web page will be updated as additional material becomes available. When an item has been updated or any new material is added, the date updated will be noted next to the item. We are now at the end of the webinar. We hope that you found this to be helpful and that it provided you with the information necessary to complete the reports. Our email, phone, and fax information is listed here so that you may contact us at any time should you have any questions. Thanks again for taking the time to view this webinar.